Okay, welcome to the class. We're going to go through an escrow class here today. I have Manfredo here with me in person, and then have 6 of you online. So if you have any questions, I'm going to mute you all that are external. And if you want to ask a question or comment, just unmute yourself. Okay. All right. Dave asked me to do an escrow class, and NVAR has what they call post-licensing class for new people, the part of the 30-hour class that they have to take. So we're going to flip through it today and answer any questions you might have. In the state of Virginia, just remember in the state of Virginia that there's 5 business banking days to get this money into the bank after ratification and a sale, and 5 days after a lease application is approved. So both ways, basically the 5 days we're going to talk about. Okay. Now, before we get into these slides that they prepared and actual written material that I want to go through, starting January 1, there is a new contract coming out. And that new contract, I went over it yesterday in a session, and we'll do another session, I'm sure, for the first of the year, hopefully. But when it comes to escrow accounts, one of the big changes is going to be that now if the buyer has not delivered the escrow check to the agent within the time frame they said they would, then the seller will have the option of voiding the contract right then. Okay, so if they said, well, we'll deliver it to the escrow agent within 5 days, and they don't, at that point, the seller can send a notice to void, and the contract's over, and they can move on with someone else. And that's going to be a big change after the first of the year, and I'll address it again as we go through this. So hopefully you can see this at home. Just a definition of what a escrow account is all about, and that's an arrangement made under contractual provisions between transacting parties where a trusted third party receives and disperses the money and documents for the transacting parties. So whatever the contract calls for, paragraph 3, we'll take a look at it here in a second. Paragraph 3 will define who's going to be the title, well, paragraph 4 in the contract title company. Okay, we'll take a look at that. So I'm just going to go real quickly through these first few slides. There's the types of trust accounts. He's going to bring you one. Okay, he's printing it. So there are different types of escrow accounts. Okay, one is earnest money deposit check. The other would be accounts held for the borrower to pay obligations such as property taxes and insurance premiums. So lenders always want to hold the money to make sure it's paid. They make it part of your payment, goes into a trust account. The ones we're going to deal with today, what happens when you receive the money. So an earnest money deposit is considered an escrow or trust. We put in the bank on behalf of the buyer or the tenant until the transaction is performed in accordance with the contract or agreement, or unless it dies. All right. So this is pretty basic stuff. We're talking about VRAB oversight and compliance, operating versus an escrow account. So the operating account is what the broker pays all the expenses and pays us our commissions out of. Okay. But all the money that comes into that account on behalf of someone else has to go into an escrow account. So when they're going to pay us, it has to be transfer it out of an escrow account into their operating account to see that we are paid or whoever else is entitled to any of the money. Okay. The maintenance part, you don't get involved with. I'm not going to spend a whole lot of time there. There are two types of escrow accounts, one for sales, one for rental. They should be separate accounts. So always make sure brokers understand, should be two separate accounts. Okay. Rules are about the same, but let's separate them. So a rental transaction, the application deposit must be deposited in a real estate account. And here's those 5 days, okay? 5 business days of approval. Now, this is a DPOR regulation, Department of Professional Occupational Regulation. We are governed by that as real estate agents and a real estate firm. So if the check is to be held by Fairfax Realty, then the broker has to have that into the bank within 5 business banking days. If it's a deposit, application deposit, which is any money received up until the party moves in. So if you get the first month's rent and first month and a deposit up front, it's called an application deposit until the contract is ratified. I mean, the lease is ratified and the tenant moves into the property. Then it becomes the security deposit. Who holds the escrow? Well, it can be the broker, right? It can be settlement or title agent, a third party, or a builder. Now, different rules and regulations. We are licensed by DPOR, okay? So DPOR has rules and regulations for real estate agents, okay? And that is, we have to have that money into the bank within 5 business banking days unless something is agreed to otherwise. But what about a settlement or a title agent? How many days does a title agent have to get the check in the bank? Well, it's not the 5 business banking days because they're not licensed by DPOR. Their rules and regulations say within a reasonable amount of time. A designated party, everybody could agree that it's not the broker, it's not a title company, it could be a third party that will hold the escrow check. And a builder, most builders do not hold their check, hold the money in an escrow. Most builders put it in their operating account. So when you're representing a buyer and they're talking to a builder and there's going to be a deposit, make sure that they understand that this goes into their operating account. That means they can use it now. They tell you it's going to be for building the house, okay? But it could be to buy their new pickup truck. So there's no protection if that builder's holding it and it's not in an escrow account, okay? Builder might have an escrow account, but more than likely it won't be. So that's how it's, who can hold it. Let's talk about here now ratification. So the money has to be in the bank within 5 business banking days of contract ratification. Now, in the state of Virginia, we have a ratified contract when both buyer and seller agree to all terms and they sign it, okay? Full agreement, terms and conditions by the parties, and they sign it. Then 5 business banking days, the check has to be in the bank. Well, part of the problem that we had in our association when it comes to data ratification is that all of our contract forms start the data ratification, which is defined when all parties had agreed. So what if for some reason the listing agent got the last change, your buyer had 10 days to do a home inspection, and for whatever reason, they didn't get the contract back to you for 3 days. Well, technically it was ratified 3 days ago. Your buyers only had 7 days left to do their home inspection. So what we have done with our sales contract, okay? Our sales contract says, just him right now. What our sales contract says is ratification and delivery starts times. So what our DPOR rules and regs say, in terms and conditions by the parties, okay, can change to 5 days. So by this definition, our 5 days doesn't start until the contract is delivered. Okay. So we're going to talk about how these funds can be disposed of and when the monies must be deposited. We've already talked about the 5 business banking days. So the exceptions to this 5 business banking days, the parties agree in writing to the transaction. So can we change it? Sure. And we did by definition in our contract. Our contract actually says it becomes a legally binding contract when ratified. All parties agree to everything. And then when it is delivered. Okay. Now, short sales. So when is a short sale contract ratified? Most people will tell me it's when the bank approves the short sale, but we know that's not so. Okay. And DPOR has made it plain and clear. A short sale is still, the seller still owns the property, the buyer is buying it. So when buyer and seller agree, then that's when you have ratification. Check needs to go in the bank within 5 business banking days, unless parties agree otherwise. So there is a short sale addendum that we'll take a look at where we can adjust those dates. Some people might say, hey, I don't want to give you my check yet, because if I void my contract for home inspection, then I'm going to then have to get a notice to void, releases, etc. So the contract could say the earnest money deposit to be deposited within 5 days of home inspection, contingency removal, etc. So what does our contract say about getting the money? We'll take a look at this and some other terms in the contract. Is an EMD required? I'm just going to flip through these slides and then I'm going to go to the written material and we'll slow down. Do you have to have an earnest money deposit check in the state of Virginia? No. Okay. You don't have to have an earnest money deposit. Our courts ruled that handshake and signing the contract is good enough. Okay. And we'll discuss that a little further. Okay. Now, as far as the failure of the buyer to deliver an EMD, I want to hold off on that until I get into the printed material. Let me see if there's anything else I want to cover. Yeah, I'm going to skip through these slides for a second because I want to go ahead to the printed material I have here. This will all make much more sense. Okay, so escrow, we talked about the funds have to be deposited. What funds have to go into this account? Earnest money deposits, rental application security deposits. That's not the non-refundable application fee. Okay, money advanced by the buyer or seller for the payment of expenses for closing of the real estate transaction. Application deposits, which is any money you receive that is not refundable with the application, and any other funds that come into your account on behalf of that party. Now, when it comes to the earnest money deposits, it can go into one of two accounts. A firm can have an account, okay? And if they do, it has to be in a federally insured depository in Virginia. The balance in the escrow accounts have to be sufficient at all times to account for all funds that are designated to be held by the firm or sole proprietorship. And that's not your responsibility, it is the broker's. Now, why would a real estate company not want to hold these checks? Well, there's several reasons, okay? If there's any shortage, they've got to explain it. So it's a real challenge to make these things balance out all the time. But I think even bigger problem is what happens when a contract dies, when a contract is voided, et cetera, and people won't agree. And this is stuck in their accounts. So I know over at the Tyson's office of Fairfax Realty, they do not hold earnest money deposit checks in their escrow accounts anymore. The check has to be made out to a title company. That way, when a problem arises, they have to deal with the title company instead of calling the broker and saying, well, the contract said we get the money if they default. They defaulted, we want our check right now. It doesn't matter what you write in the contract. Brokers have rules they have to follow for releasing of the money, and then people get all belligerent. So we just cut that step out. Now, we talked about the types of escrow accounts and the operating. Now, who holds the funds in escrow? So if it's escrow agent is a broker, then it's regulated by the VREB. If it's the escrow agent title company, it's regulated by the Virginia State Bar. Okay, different rules than we have. And if it's a designated party or builder, there are no regulations or protections for the parties outside of any escrow agreement. Okay, and there's none, right? So when you make sure these people understand that builder's holding it, your deposit could be at risk, especially if they go out of business. So date of ratification. All time frames for the deposit of the funds in escrow to begin upon ratification of a contract. Then 5th business banking day, this money must go into the account. Okay. Now, we're talking business banking day. Okay. So if the bank isn't open to do all their business on Saturday and Sunday, those days do not count. Holidays do not count. Okay. Now, here at Fairfax Realty, all deposits and all paperwork have to be submitted within 3 days. That still gives a couple of days for the company to get the money into the bank and have recordation of the fact that you actually did a transaction. Okay. The exceptions to the rule. Parties can agree otherwise in writing in the contract, especially in a short sale, when you use the short sale addendum to delay the deposit of the funds into the escrow account till after the lender approval. Okay. So let's look at paragraph 3 of the current contract. Okay. Buyer's deposit in the amount of, if it's a check, okay, and or by note due and payable on, shall be held by escrow agent. So let's discuss this for a minute. DPOR has come up with some things that they have said, look, you guys been doing this, getting away with it, but it was never right. So now we're including it in our regulations to make sure you understand. This check, if I give you a check, it must be cashable now when I hand it to you. If I tell you, I need to make some arrangements, I need to move some things around, what did I just tell you about this check? It's worthless. It can't be cashed right now. That is a direct violation of real estate board rules and regs. You know they're going to bring a check back to you tomorrow. but you haven't received, they didn't have the checkbook with them. For you to put in here that you have received a check is a violation. To use this one check to attach to more than one contract is a violation. You have to have a separate check dedicated to that property, or it's a violation. So if I am in town and I want to write multiple offers for contracts, you can't make a copy of the same check and attach to each one. Okay. I just voided my contract. The money's in the escrow account. I want to use that same check to write another contract. Can we use that same check? No. D4 says that check's already been used. And until all parties release it, those funds aren't available. You need to write another check. Well, if I've given you all the money I have with this check, and I can't get it back even when I void my contract for a home inspection, unless the seller signs a release. And even after the seller signs the release, the broker has 20 days to give me my money back. You can start seeing why I might not want to give you that check until when? Maybe after my home inspection contingency removal or the short sale approval. Okay. So D4 is saying if you don't actually have the money in hand, then the buyer has not delivered the deposit. You would have to check, will deliver the deposit to escrow agent by X number of days after date of ratification. Okay. Now, this is all changed beginning the 1st of January. Okay. All this language about being in the account within 5 business banking days and all that will be removed. They think that you should know what the statute says. Okay. It will also have the clause that the seller can void the contract if this check hasn't been delivered in this X number of days that they said they would deliver, up until the time that they do deliver it. So what they're saying, and they're changing it in our contract, the fact that the buyer did not deliver the check back to me in the 5 days doesn't mean we no longer have a contract. The buyer has breached the contract, which could be declared a default, but you still have a contract. What they're now saying is, okay, you had 5 days to do this, you didn't. The 6th day, the seller can send a notice over to void. But say the seller doesn't send it on the 6th day, and now I deliver the check on the 7th day. Well, that right for the seller to now void because the check hadn't been delivered is gone. The breach has been cured, no longer a default in the contract. And at the end of the class, I'll pull up the new contract form so you can see that part. Okay. Any questions about any of this? So let's look at how this money can be given back by the broker. Okay. It can be credited towards the sales price at settlement. Now, let me give you a little warning about this, or just a caution. If the deposit that you're holding is more than the commission to Fairfax Realty, if they're holding the check, you need to go to your manager several days prior to settlement so that the money can be moved from the escrow account into the general operating account so that the money, you can get that check to the title company for the difference. You understand what I'm saying? Our commission was $10,000. The earnest money deposit is $15,000. That money has to be at the table to be credited towards the sales price. We're only entitled to 10 of it. Where's the other 5 coming from if that money isn't sent by the company to the title company. So make sure that you don't fall into that trap, because I've seen some people charged with that one. Okay. All parties agreed in writing what will happen to the deposit, or a court orders disbursement and all appeal periods have expired. So if, as a broker, I'm holding the deposit and the parties can agree in writing as to its disposition, at that point, I am going to send what we call, used to be a 30-day letter. I am going to send a 15-day letter saying to the party that gave us the money, or all parties actually, look, this is what the contract says. I'm going to disperse it this way unless somebody objects. Once they object, then I can't give the money back out no matter what the contract said. So then I am going to go to the courts, okay, and say, here, court, here's the money. It's called an interpleader. I'm going to interplead. Here's the money, okay? You figure out what to do with it. Or if one party sues the other party and then the court rules and that order is sent to me and the appeal periods have expired, then I'll cut it out, okay? So I don't care what you guys write in your contracts about, hey, we're giving this extension, but the earnest money deposit is automatically forfeited to the seller if, you know, you don't settle on this extended date. That's fine that you guys agreed to it, but the broker has rules and regulations about getting the money out. And if the title company's holding the money and you take that over to them, what do you think they're going to say? Same thing, you know, we need what? Releases. So is a EMD necessary in the state of Virginia? No. Okay. Mutual promises in the contract, handshake, good enough. This is your rental application. They talk about the fee with the application up front. Once the lease is signed, the landlord signs the lease and the buyer signs the lease, then that money that we had as an application deposit must be in within 5 business banking days after the application has been approved. This is why a lot of people don't want the application fee until when? All they want is upfront. We want the non-refundable fee of processing, okay? So, and the credit check fee, and then within 5 business banking days, whatever, after ratification, bring us the checks, and then it'll go into the bank. Okay. Now, this is a pretty good point here. You know, we have uniform rules across Virginia. Different regions have different forms. Northern Virginia, very highly unlikely that a contract would be considered without the EMD, even though ratification says we can. So let's go back up here to this deposit paragraph. You'll notice that I could give you a check, or I could give a note, due and payable on such and such day. Now, what if I were to offer you a $100 check and a $9,900 note to be payable within 5 days or 3 days after I removed my home inspection contingency? Can we do that? I'm going to open it up to you guys at home. What do you think? What do you think if you got a contract on your listing and it said $100 check and a $9,900 note? Anybody? What would you tell the seller about that kind of a contract? You would probably what? You'd probably say at that point, hey, I'm not sure these people are really serious, okay? Because they're not putting up money. But as a buyer's agent, I'm thinking, why tie that money up if we needed to go do another contract and people won't agree to release it. So it's a function of the market. Right now, you probably wouldn't do it. What if you had a listing for 9 months with no contracts? And this is the first contract you have in 9 months, and it says $100 check and a $9,900 note, probably won't have a problem with accepting it then. So it's really a function of the market, right? They tell us a definition of application deposit in our statute. That's any refundable deposit of money that you receive up front. The application fee is a non-refundable fee. It's maxed out at $50, exclusive of out-of-pocket expenses paid by the landlord to the third party performing background credit or other pre-occupancy checks. So you can get a $50 processing fee plus the credit check fees. If it's Department of Housing, HUD, subsidized housing type situation, is $32. The security deposit is the refundable deposit of money that the tenant gives the landlord to secure the performance of the terms and conditions of the agreement. However, that application deposit might be one and the same. That's probably going to be the same money used. Then it would be switched over to the other application, the other account. Now, how can the brokers disperse this? We just looked at it in our sales contract. That language is staying so people understand, okay? All parties agree to the disposition, okay? But the broker still has 20 days after that to give the money back, okay? The court says, give it back, I'm giving it back, or here's interpleading. So I interplead to the court, said, look, I've sent the 15-day objection letter. The party objected, so I can't get them to agree. I don't want it in my account anymore. Here, court, you figure it out. The court will call everybody in at that point. They decide what happens to the money, gets out of my account. And what I've recommended to brokers is that you scrub your account a minimum of every 60 days, but probably 30 days. Any money that's stale, get rid of it. And they can't hold it for more than 5 years anymore in an escrow account. So definitely need to send those letters and get it out of there. Okay. And to be the broker sending those letters out for us. So we can, once again, that's just a repeat. Is there a statute of limitations on the written contract? Yes, 5 years. So that would be a 5-year limitation on the escrow deposits. Can interest be paid on these accounts? Yes, but interest is not required since 2016. Here's where you could run into a problem. So I want to slow down here for this part. Improper maintenance of escrow funds. Accepting any note, non-negotiable instrument, or anything of value not readily negotiable. You know, in the old days, I had a horse for an earnest money deposit. I'm not sure that I could do that anymore. If everybody agreed in the contract, we probably could, right? What does commingling of funds mean? That means combining your money with escrow money. A broker can put a certain amount of their own money to start an escrow account, okay? But they have to identify it in the records and keep it that way, okay? Otherwise, that's called commingling also, all right? Or the way it really happens is a broker starting to run short on some funds and they say, well, I'll just take some out of here, nobody will miss it, and then I'll put it back in later. Been several brokers that gotten in trouble for stuff like that. So, you know, that wouldn't affect you. Failure to deposit funds in an account so designated, failure to maintain sufficient balances. And here we go. Failure of the principal broker to report to the board within 3 business days where the broker believes an escrow violation may have occurred. Here's the deal. We have 5 business banking days from ratification. If you don't turn the contract and the check into the broker in that amount of time, they have no choice but to report you to DPOR for a possible violation. If they don't, they're going to be facing a charge with DPOR. Don't get upset with the broker. They're just the messenger. They have no choice. So what are some of the things they can do to you? Okay, 1, they can fine you money. 2, tell you to go take a class and you won't get any CE credit for that class, okay? They could suspend your license or they could revoke it. When you receive a penalty letter from DPOR, I know this is escrow account, but please, please read the entire letter. I remember when I came to work here 11 years ago, you know, the letter had a fine and everybody said, just pay the fine. But at the bottom of the letter, and revocation of license, they were going to take the person's license. I said, did you read this? You're agreeing to this? You no longer want to be an agent? Okay. So we were able to overcome it by me writing letters to DPOR stating that people had been taking my classes voluntarily, you know, prior to even being charged or heard. So they removed the revocation part and put it to supervised activities for 2 years, reports filed. So the fact that you attend these classes, important for us to have a record of, okay? Any questions about any of that? Before we look at these do's and don'ts, I want to go and pull up some forms here. I believe I have some here. That's the real estate board rules and regs. This is the short sale contingency form. If you get involved in a short sale, I just did a short sale class here last week, and I think there's going to be some short sales coming up. If your buyer is doing a short sale, you want to use this short sale addendum form, okay? And it defines stuff for them. But back here is the part that I'm interested in, the time frames, okay? Time frames. So we can adjust the time frames with written agreement. The deposit delivered to the escrow agent pursuant to the deposit paragraph or within X number of days after the seller delivers creditor approval. Same way with the inspections. You want to, with inspections in a short sale, your buyer might still need to do the home inspection to be even considered for the short sale, okay? The same, the appraisal would probably have to be ordered up front. The one thing you want to adjust is the deposit part itself, okay? Hold on 1 second, let me shut this door. Me. So when it comes time for a short sale, make sure that you use this short sale form, okay? So let's talk about some do's and don'ts here. Okay, if the transaction is not completed and all principals to the transaction have agreed in writing as to the earnest money deposit disposition, the funds must be returned by the broker within 20 days. Make sure people understand the 20 days. Now, when a contract is going to be voided, say for condo docs or POA or whatever, they first have to void the contract with a notice to void and then use the addendum form that says release of contract and deposit. Okay, two separate actions. We'll take a look at those forms to make sure you understand in a few minutes. Regulations clarify that unless the principals agree in writing, prepaid rents and any funds come in on behalf of the landlord must be in the bank within 5 business banking days. The new prohibitions, okay? I've told you about these. Not use the same copy of a check. Don't represent that you received your earnest money deposit when you know the check is worthless. I need some days to move some stuff around. How many days do you need? Well, 10. Then we're going to put in here that you will deliver the check in 10 days, not that I have received it. Not misrepresent who is holding the EMD. So the check, you're holding the check, but it's made out to a title company. Okay. Don't do that. Make sure the check is delivered to the title company. You don't want to be holding that money yourself. I usually say, hey, you need to get this over to the title company. Matter of fact, if you're going to buy a property anyway, why don't we deliver it to the title company before we start our search? Licensees have an obligation to submit their deposit to brokers in a timely manner. You are now charged by DPOR that if you don't turn this stuff in a timely manner, all the paperwork, they're coming after you. It used to be the broker, right? No commingling. We've talked about that. We talked about the earnest money deposits. Once a deposit has been described in a sales contract, okay, it must be accounted for even if there is no ratification. So if you have the check, okay, and it's not ratified, then that check needs to either be given back to the party or turned into your broker to be held in a file until it is returned. So don't let it out of your sight. You don't take non-negotiable checks or funds. You do not take any post-dated check. You don't take a backdated check, an altered check, or a stale check. And I know agents keep the same check in their file. Every contract that you write should have in the remarks section the property address that that property is being used for. Never hold a check upon the request of the buyer. In other words, we used to get the request all the time. That's a lot of paperwork there. That could probably get lost in that folder for some time, couldn't it? Well, no, I've not received it. Can't do that. I think that one makes sense. Use a fresh check. Drop off checks immediately after contract ratification. They're saying 48 hours to your broker. Our policy is 3 days. Better. Always use a different check for each offer. fact that you're holding the check that it didn't get delivered does not protect you. Now, it's said in the contract that you would bring the check back to me within 5 business banking days. You do not. At midnight on that 5th day, as the buyer's agent, I have to notify the other side that you have not brought back the check, okay? They're going to yell that that's a default and we're voiding the contract. Well, it's a breach of contract term that could be a default. Our new contract defines it as a default, but it's only a default if the buyer doesn't settle, okay? That's when it would actually become a default. I want to leave this and pull up our sales contract. And this is the new residential sales contract. While we're right here at the beginning, I want to make sure that you also understand that if you are with a different firm than a listing firm, you can only represent the buyer in the state of Virginia. There is no sub-agency. So they removed where the co-op broker represents the seller. It's impossible to do. So I'm finally glad they did away with that. But this is an escrow account class. Let's look at paragraph 3, what they have done here. The deposit, this part hasn't changed, okay? Escrow agent is the party that will be handling it. If it's Fairfax Realty Select, the check's made out to Fairfax Realty Select, and the buyer hands you the check, then they have delivered the check to you as long as it is a good check, those things that we discussed, right? Now, if it's made out to RTS title, they hand a check to you, then you have to check they will deliver the deposit to the escrow agent within X number of days, because you don't work for RTS title. They took out all that 5-day stuff. That is all statute. By having it in the contract, people thought there was a possibility that you could negotiate terms that are written in the contract. If it's by law, you can't change it. So now, if the buyer fails to deliver timely delivered deposit as provided herein, seller may at seller's option deliver buyer notice to void this contract. Once that seller delivers that notice to void, all respective rights and obligations of the parties arising under this contract will terminate. There is no longer a contract. However, if that buyer delivers that check to the deposit agent prior to seller delivery of the notice voiding this contract, then they've cured the default. Everybody clear with that? So it said 5 days here, the 6th day, the notice is sent, contract is over. Seller doesn't need releases signed. They could go on with a new contract that they like better. But if they didn't send a notice on this 6th day, and the 7th day, the buyer delivered the check, then they've cured the default. We move forward. Okay. They've also said here that the deposit will be deposited by the escrow agent into an escrow account with applicable state and federal law. So rather than spelling out the 5 days and all this other stuff, they pulled all that out. You should know what the rules are if it's a depot agent holding it or a title company holding it. All right. And that's what changed with that paragraph. Now, when it comes to settlement, the date that you put in this blank is written in stone. Okay. If for some reason, okay, that your buyer cannot settle, you need to put them on notice, okay? That by not settling your deposits at what? Your deposits at risk. Okay. So if we go back here to one of the things you'll notice about this contract is 2 pages shorter. Okay. We go back here to default. Okay. If the buyer fails to complete settlement for any reason other than default by the seller, buyer will be in default. At the option of the seller, the deposit may be forfeited to the seller as liquidated damages and not as a penalty. Okay. So if you have a settlement that's supposed to happen today at midnight tonight, that contract no longer exists. Okay. And your buyer is responsible for all the damages, which could be the deposit. Okay. It is your duty to keep them informed as they get closer that they're at risk. So paragraph 30, what does time is of the essence mean? It means that the dates and timeframes agreed to by the parties must be met. They're not suggested guidelines. These are drop dead times. Failure to meet those dates and timeframes result in the contractual rights, waiving of them, or default. And once there's that default, that time reaches for the settlement, there's no longer a contract. It doesn't mean that the parties can't agree to extend everything in the contract, but it has to be done prior to midnight on the night stated. Everybody okay with that? And the fact that the lender just needs a couple more days, okay? If the seller doesn't agree to it, the party's in what? Parties in default, okay? And their deposit could be at risk, not only their deposit, but other damages also. Any questions about escrow accounts? So basically, what do you need? Okay, basically, we're talking 5 business banking days from date of ratification of the contract. Unless parties agree otherwise, 5 days for rental deposits from signing of the lease. All have to go in an escrow account. Keep your parties informed so that they don't run the risk of losing their deposit because the seller will not give additional days. Any questions? Yes, yes, Manfredo.
Just to be on the safe side, whenever is the defendant's money deposit moving to Fairfax Realty, so we do have the 5 business days, right?
5 business banking days.
And if it's to RTS, a title company,
their rules, the state board rules, see, they're not part of DPOR.
right?
So the question is, if it's made out to the Fairfax Realty, then there's 5 business banking days from date of ratification, okay? If it's a title company, their rules and regulations by the board, lawyer board says a reasonable amount of time. Now, where you don't want to run into a problem, holding the check that's meant for a title company past 5 days. And the reason you probably don't even want to handle the check made out to the title company and have it in your possession, what if they stop payment?
I mean, I would just deliver it anyway,
Yeah.
within the 2 to 3 business as usual, but I would just
Yeah,
want.
but my point being, and let me bring up the contract again here. Let me bring up the residential sales contract again.
I would just deliver in the next, usually 2 days that I do, but 2 to 3 days, but
Okay, so the question is, you have the check in your hand made out to the title company, and you filled out this paragraph. Okay, and it says the buyer gives a check of $5,000 be held by RTS Title Company. Okay, and then you check the buyer has delivered the deposit to the escrow agent. Okay, now what happens if you don't deliver this check to RTS for 2 or 3 days? But you've already checked in here, the buyer has delivered it. And what if that buyer stops payment on that check because they changed their mind and they don't want to buy that house? As an agent, do you think you have a problem? Yes, right? So if the check is made out to the title company and you're holding it, okay, then check, they will deliver within, if you say 2 days, 2 days, 3 days, whatever, that they will deliver it. Okay, now what I would do is I would make a copy of this check that's made out to RTS Title. Okay, and I would let the other party know that we have this check made out to RTS Title and it will be delivered within 3 days. Okay, now here's a problem that I'm running into with fraud. We have a tendency to send a copy of this check written by the buyer, and they give this check to us. And we send it along with the contract through an email to the other side so the contract can be presented. And that check has on it the buyer's name, their address, their routing number, their account number, and their signature. And we're sending this over an unsecured system where somebody could get into the system, have all that client's personal information. I do not understand why everybody feels we have to send that information to the other side. If you're going to send a copy of the check, make the copy, take a dark marker, and make sure you mark off all that personal information so it can't be used against the party. Okay. Now, the statute says you received a check. Okay. What if you don't turn the check in to the bank, to your broker, so that it gets in the bank until the 7th day after ratification? And then what if that buyer stopped payment on that check on the 6th day? Okay. Once again, you have a problem. Okay. Now, if they stop payment on that check in that first 5 days and the check was put in the bank, now it's a problem between buyer and seller. But you want to stay out of the sight of DPOR, right? You don't want to have to be going through this with DPOR. So be careful with these checks. Has to be a good check. Get it into your broker right away, next day if possible, so that they can get it in the bank. And if there's a problem with the check, then it's between the buyer and the seller, not us. Okay. Any other questions about escrow checks? Okay, for those that joined me today, thank you. I'm going to have to do another session on the contract. There was some kind of a mix-up. I only had 5 people for the new contract yesterday, and some people thought that it was today. So I'll try to set up another one after Christmas to see if we can get another session out and let you know. Also, for those that are joining that don't know, all the previous sessions of Ask Larry or anything I do or any other person does training for the company, there is a YouTube site that you can go to. And Nestor, I see he's on here today, he's recording this for us. So Nestor maintains all that for us. Thank you, Nestor. And you can go to that YouTube channel at any time. And the link to that was in the email that you received about this class today. Okay. So thank you guys very much for joining me. And that's what I have for you on escrow accounts. No other questions, and I'll see you in the next session. Thank you for attending.
Thank you, Larry. Happy holidays.
Same to you.
Thank you, Larry.
Thank you, guys. See you next time.
Okay, all right, thanks.
Okay, thank you.
All right.